This is an application in the matter of Manolete Partners PLC and White.
Good morning. Perhaps I ought to start by addressing the issue in relation to the respondent's notice. As you will have been informed, we didn't make a decision in advance of this hearing. We have had now the opportunity to consider all your written submissions in relation to it, and we consider that the application to file the respondent's notice is late in the day, but it raises very important issues. They arise, of course, only if the appeal is allowed, or probably only if the appeal is allowed. To put it this way, we consider that at the moment, this important point is not thoroughly canvassed in writing. It's not dealt with on one side, and on the other side, it's without any intention to be in any way disrespectful, is dealt with relatively glibly, let's put it that way, for such an important point. And we think that if and to the extent that it arises, it would be necessary to have a further hearing. We don't think that those issues, which are, as we consider, very important and very wide, can be dealt with today within the time allotted. We would need and want to see the relevant rules of the pension scheme, the original judgment in relation to breach of fiduciary duty, which I don't think we have, the pleadings in that case. We'd like to have an opportunity to think about the legislative history, which leads up to that wording in relation to criminal negligence and fraud, which is relied upon in section 91(5), and extrinsic evidence, which is admissible in relation to construing those words in that subsection. None of that would be before us if we were to seek to deal with this today. And so, and certainly the appellants are not in a position properly or at all to deal with those matters. And so we don't propose that it be dealt with today, but we are not saying that it may not be relevant and that it will not be dealt with in the future, put it that way. With that in mind, I assume, gentlemen, that you have divided your time between you and you know how the timetable will pan out today in relation to the issues that we are going to deal with.
Grateful for that, my lady. Of course, we were waiting to hear the court's decision on that in terms of what time we did have available to us today. In my submission, I speak for about an hour and a half to 2 hours of this morning, and then Mr. Keele have a similar amount of time to respond. Then any reply, and that makes good use of a day in my submission.
Thank you very much.
In terms of, I should begin by saying I appear with Mr. Comiskey for the appellant. My learned friend, Mr. Keele, King's Counsel, appears with Mr. Colclough for the respondent. You should have, my lady, 3 bundles now, one being, or perhaps 4 if we include authorities. So there's an appeal bundle, a supplemental appeal bundle, and a second supplemental appeal bundle. Although I think I'm right to say the second supplemental appeal bundle only goes to the respondent's notice. So provided you have A and B.
I have A and B, I don't have C with me. Okay.
I don't believe the court will need C. And also, of course, an authorities bundle.
Yes.
In addition, of course, for skeleton arguments of the parties. I want to address the court, after a short introduction, on 5 principal matters. One will be Section 37, the jurisdiction under which the order was granted. Second will be general principles of statutory interpretation. Third will be the correct interpretation of Section 91, as we say in this case, or in any case for that matter. Fourth, the application in this case. And fifth, the authorities that suggest to the contrary to our appeal, including the decision of His Honour Judge Hodge, King's Counsel below. By way of introduction, my lady, this case is, we think, the first time that the question whether Section 91, subsection 2, prohibits a blight and booster order has been argued actively. Our point is that section does prohibit a blight and booster order because the effect of such an order is to give effect to the alienation of the pensioner's rights as opposed to income, present income, in his pension, contrary to the inalienability provisions of section 91, including in particular subsection 2, which prohibits the court from making an order that has that effect. The underlying principle, we say, is that occupational pension rights are to be preserved for their purpose and should not be available to the petitioner as if they were any other asset, including for attachment by the petitioner's creditors. The principle that judgment should be enforced is not in dispute, but we say there's a competing principle as expressed in the Good Report and some of the case law, which is that pensions and their favourable tax treatment of monies going into pensions may merit special protection from creditors and from the pensioner's own improvidence. In turn, that encourages people to put money into their pension and save so that the burden of their old age doesn't fall on.
Your submissions are, when you say pensions and pensioners and putting money into their pensions, are you saying pensions generally or just occupational pensions?
Just occupational pensions.
Because that's a key distinction, which, speaking for myself, I'd quite like you to assume a dummy's knowledge of the difference between an occupational pension and any other form of pension.
Yes.
So don't assume that certainly this member of the bench is completely familiar with the minutiae of the difference.
Very well.
I mean, especially when you look at this case and you see essentially perhaps a different picture of an occupational pension than might have been contemplated by the legislature and the people in reports, where you might have a big company and lots of employees.
Yes.
As opposed to with no disrespect, a one-man company.
Yes. I mean, it wasn't in dispute below that this was an occupational pension.
No.
And it's not been disputed on this appeal that it is an occupational
pension. I take it that it is an occupational pension, but because I'm thinking about what are the characteristics, for example, of drawdown with an occupational pension? What is the nature of the right that we're actually talking about? That I certainly for one would benefit from understanding.
Very well. Well, hopefully I'll address it as we go along. We have the scheme rules, of course, that are in place, which are in the bundle. I think at page B31 is the scheme rules of this particular pension. And the right that was relied upon below to draw down was in 6A and 6C. So 6C was the members' drawdown pension fund.
Sorry. I'm terribly sorry, I don't. In the...
Tab 2 in supplementary bundle.
Yes.
There's the Standard Life's General Rules, page 115 of the bundle.
Thank you.
Sorry, I have a reference to B31.
Yes, and it's also got B31. Thank you.
And sorry, the relevant provision that you were referring to?
I believe below what was relied upon was 6A read with 6C. So essentially, once a person becomes over 55, they can start to exercise rights to draw down their pension. If they don't do so, then when it crystallises, then they are left with a drawdown pension fund under 6C. And they can choose how to draw that down in each drawdown year. So what was said by the respondent was, therefore, the appellant could draw down his pension in full now that he's over 55 because he has those rights. And in fact, he has the rights as a matter of general law because it would be a fund to which he was absolutely entitled. So effectively a Saunders and Vautier situation where he could simply call for it to be delivered up.
Okay. Thank you.
So the significance of the distinction, of course, is that Section 91(2) applies to what are termed occupational pensions of the Pensions Act 1995. It doesn't apply to personal pensions, and so that's the distinction.
And many of the cases are about personal pensions. Yes.
Some are, yes.
Some are, some
aren't.
Yeah.
Yes, Lydia, and I'll try and highlight that as we go
Yes.
along.
Well, and specifically, I mean, is it Python Priester is
Personal.
personal? Not
We believe.
occupational.
Well, I think it wasn't absolutely clear what the pension was in Brighton Brewster from the report, but subsequent courts have said it's assumed it was a personal pension rather than an occupational pension.
Because otherwise you would have thought that this sort of point might have actually occurred to somebody.
Well, you would expect Section 91(2) would have been cited to Mr. Moss, Queen's Counsel, as he was.
Yeah.
At that point, if it was squarely an issue, because in fact the argument was made in a slightly different way, which one would expect 91(2) would have been referred to.
Yes, sorry.
Yes, so that brings me nicely back to where we were in another point. In respect of occupational pensions, and in my submission it's all occupational pensions, the Parliament has extended protection to pension rights outside of bankruptcy as well as inside of bankruptcy. So the nub of our argument on this appeal is the court has to look at the purpose of Section 91(2) in its statutory context. The best guide, we say, to that is subsection 1, which prevents assignment and prevents the pensioner themselves dealing with their occupational pension. We say that informs what then subsection 2 is supposed to do, which is to stop the court doing the same thing. We say the good report is the other good guide to what the provision means, and that proposed that occupational pension rights, as opposed to payments, should be protected from attachment. That reading of the report, we say, has been recognised by the Court of Appeal on 3 previous occasions, and I'll take you to those cases, my lady, in due course. Judge Hodge below took a different view of its application or what it meant, which we respectfully submit was a misreading of the report. He apprehended that the distinction was between existing and future rights to payment, whereas we say the true distinction is between payments, i.e. pensions in payment, so where an election at least has been made to draw down or a payment is received, and rights to payment in the future once an election is made. We say that's the real distinction. The statutory scheme is to protect rights, and that's understandable because it allows income to be attached in the usual way, but with safeguards for living expenses. The order in this case throws Mr. White's cost of living in old age back onto the state, which we say defeats the purpose of Section 91 and in particular subsection 2. There's of course a stark difference between an income payments order and an attachment which might be made on the income once it comes in, which is that the court can then mould that order so as to make sure that the pensioner has a living allowance that they can get by on. The effect of Judge Hodge's order is to take the whole of the pension fund, have it drawn down and paid to creditors, or to Manolete in particular. Manolete's response to that, we say, is to rely on a linguistic analysis of some of the words of subsection 2, namely restrain and receive. That ignores the words the effect of which are in the section and must be there for a reason. It also suggests a two-stage approach, which Manolete itself recognised was a pure matter of form below and was recognised as a pure matter of form in Batchy. The lacuna, we say, in the respondent's argument, is that they can't identify what then is the purpose of subsection 2 of section 91 if it isn't to prevent attachment, as the good report would suggest it is, and there's the whole scheme of why section 91 is there, which is that pensions shouldn't be enforced against because they've got a special status. Then what's the purpose of subsection 2? Surely it can't just be to make sure that a pensioner receives it so that they can pass it on to someone else. So we say A good report and the case law will demonstrate that Section 91(2) is to prevent attachment against rights, occupational pension rights, I should say, just as the pensioner can't dispose of them himself. I'll move on then to my first area of my submissions, which is Section 37 of the Senior Courts Act 1981. It's in the Authorities Bundle, tab 3. The court is no doubt familiar with it. It was recorded in the recital to both orders made by His Honour Judge Hodge below, that the main bundle, page 64, the words, the second recital is upon the application being made pursuant to Section 37 of the Act. And the same words appear in the subsequent order at page 96 in the same bundle, again the second recital. We say, my lady, that it's important to have in mind the basis of the court's jurisdiction to make a so-called blight and boost order under Section 37. Because although the power of the court to make an injunction, and it's an injunction we're dealing with here, is broad, it must still be exercised in accordance with principle and authority, or an acceptable incremental development of authority. Now in Batchy and Green, which is the case at tab 29 of the Authorities Bundle, the court looked at the jurisdiction to make the order in this case. This was a claim brought in debt, deceit and dishonest breach of contract, and where at first instance Mr. Hockhauser, King's Counsel, made an order to the effect of a blight and booster order. It then went to the Court of Appeal, and as I say, paragraphs 14 to 29, the court deals with the question of the court's jurisdiction under Section 37. In that case, what had happened was the defendant had borrowed money from the claimant on the strength of security over various artworks, of which, in fact, he wasn't the true unencumbered legal and beneficial owner, so the security wasn't worth what he had represented, hence the judgment, which was a summary judgment, and then the defendant went bankrupt. But the debt wasn't released because of Section 281 of the Insolvency Act 1986, which provides that fraudulent debts aren't released by discharge from bankruptcy in the usual way. So subsequent to that, the claimant sought a blight and booster order, as we call it, requiring the defendant to draw down on his pension, including by revoking enhanced protection under the Finance Act, so as to receive an additional lump sum on drawdown. Yes. The defendant in that case didn't, in fact, dispute that blight and booster was correctly decided, nor that the court could grant relief under Section 37, requiring a debtor to call for his pension. And you can see that at paragraph 14. This was, of course, an occupational pension, hence why it was Section 91 was mentioned by Mr. Hockhauser below. So far as jurisdiction was concerned, though, the appeal focused on whether ordering the defendant to revoke his enhanced protection was a step too far, and the court can no doubt appreciate the difference. It was requiring the claimant to create property rather than what we're more used to with injunctions, which is merely to protect some existing property. So that was challenged. That enhanced protection element was challenged by the claimant on that by the defendant, I should say, in that case. And so it required the Court of Appeal to address the basis of the jurisdiction to answer that argument. Lord Justice Newey dealt with it first at paragraph 14 and 16. He says at the bottom of paragraph 14 that Mr. Murren, who was counsel for the pensioner, did not quarrel with the proposition that in one sense the court's powers to grant receivers and injunctions under section 37(1) are unconfined, where the person is within the jurisdiction, but the circumstances in which it is proper to exercise those powers are nonetheless limited. And 15...
You wouldn't disagree with that?
No.
The power is broad, but it has limitations.
Exactly, my lord. I'm taking you to this case to show you exactly where the jurisdiction was said to come from in this case,
Yeah.
to make the injunction, because I say that informs the context of part of what the respondent says, which is, well, they're two separate stages, and actually he receives his pension, so section 2 doesn't apply.
Your submission essentially is that you can't use section 37 to thwart the purpose of section 92.
Yes, my lord.
Of course, starting point is what the purpose of section 9, but once one's got that in mind, it would be improper to use section 37 to defeat that statutory purpose.
Yes, exactly right, my lord. And that was, of course, recognised by the Privy Council in the Broad Idea case, which is quoted lower down the page, at the bottom of the page, where Lord Leggatt, with whom the rest of the court agreed, said the powers of the equitable jurisdiction to grant injunctions are subject to any relevant statutory restrictions. So we would say, well, section 91(2) is a statutory restriction. But it goes more than that, my lord, because it goes to the nub of what the respondent is arguing, we say, which is they say, well, he's receiving his pension, he just has to use it to pay creditors. And we say, well, that's an artificial way of looking at the order, because for jurisdiction to make the order only comes from the fact that the jurisdiction is exercised so that the pension can be attached. And so you can't look at the order as two steps. And that's what Mr. Hockhauser says in this case, that the two are integral parts of each other. And the Court of Appeal approve that themselves also. So 14 and 16 deal with that point that your lordships intervened on. Lord Justice Arnold will look at, he took a slightly different view of the source and constraints of the court's powers, but it shouldn't need to trouble this court on this case, because this is the same kind of injunction. At 17 to 22, Lord Justice Newey dealt with the power to appoint a receiver, and as an adjunct to that, the power to order the defendant to revoke enhanced protection. And he says at paragraph 23, where he turns to the question of an injunction as the alternative, that the power would have been proper for the court to assist creditors simply by granting injunctive relief. And then at 25, he says, the creditors have the benefit of an unsatisfied judgment against Mr. Green. His only material asset is his interest in the pension scheme. They thus have a clear interest in obtaining recovery through Mr. Green's pension rights, and facilitating that would be in line with the policy that judgments of the English court should be complied with and if necessary enforced, and so potentially the demands of justice.
That can't be an unrestricted right, though. Certainly not in relation to occupational pensions.
Well, that's our point, my lord. Yes.
Well, stated as broadly as that. I mean, it is true the creditors have a clear interest in obtaining recovery. That's what they plainly do. But the question is, on any view, that there's a restriction in relation to that, which Parliament has put in place in relation to occupational pension schemes.
Yes, my lord. As I say, we say this looking at the jurisdiction though is relevant to when the respondents say, well, the restriction doesn't actually apply because he's received it. So subsection 2 doesn't apply whether they've received it. And we say, well, if you look at the point of the order, the jurisdiction to grant the order, it is actually not that he received it beneficially. He receives it really in a ministerial capacity, like a bank would, just simply for it to go through his account, for it to be attached. But yes, here there is a two-step principle in my submission. First of all, the court has to look at what's the jurisdiction to grant an injunction, and that has to be subject to some principle even though the power is broad. And then secondly, well, if you have that power, it can be subject to statute. It is subject to any applicable statutory restrictions. There are further comments. I think the bench has some points there. I won't go through it at length. There's further comments by the court, or by Lord Justice Newey at paragraphs 23, 25 and 26 to a similar effect about the injunction being to assist creditors. So ultimately, he therefore considers that there was jurisdiction to make an order. I should perhaps pause and deal with paragraph 33 while we're here, because here he deals with what was put forward as a policy argument before this constitution of the Court of Appeal, which was that there was a policy that meant that pension rights in bankruptcy should be protected. Section 91(2) wasn't relied upon. Clearly, it's very different if the court is dealing with simply a question of public policy as opposed to statutory provision. And in fact, in my submission, what Lord Justice Newey says at paragraph 33 implies that had subsection 91(2) been relied upon, he would have taken a different view, because his point is that mere policy won't stand in the way, because if Parliament hasn't thought right to protect for, essentially, the hypothesis is occupational pension rights prior to bankruptcy. Well, in fact, in our submission they have, and had that argument have been made to him, his decision might have been different. And just for completeness, Lord Justice Mayles is at paragraph 44 to 45. He says the remedy sought is in support of a legal right to payment. Of a judgment debt. Lord Justice Arnold, as I say, differed on whether or not technically the power came from section 37(1) or section 37(1) effectively consolidated an existing inherent jurisdiction or jurisdiction from the cases. Nothing turns on that in my submission. He also differed on the question of whether they were subject to constraints, if constraints means limits. But of course, must accept that where there's a contrary statutory provision, then that would be a constraint, of course, on a general power. He accepts at 49 there must be a principled basis for the exercise of jurisdiction. But that doesn't mean that practice can't change. And he says at paragraph 53, as Lord Justice Newey has explained, there is a very clear principle basis on which to exercise jurisdiction, namely to achieve justice, or more specifically to enable a judgment debt to be partially enforced against a fraudster. It is worth noting, my lady, the reference to a fraudster. Blight in this case, Blight and Brewster, and the cases at paragraph 28 of Manolete's skeleton argument, the defendant was a fraudster in each case. Now, in this case, we say section 91(2) applies, so don't need to go into whether that's a limit on Blight and Brewster or not, but I just mention it as we pass that statement by Lord Justice Arnold. So in this case also, my lady, the idea that the Blight and Brewster order was one where the requirement to draw down was to be viewed as an integral, not in isolation, but as an integral part of an order to allow attachment, was recognised in this case as well below, both by the court and by the respondent at that time. So there's first of all the application notice itself, which sought the relief, which is in the first bundle, page A111. And it was then as though Callaghan's witness statement in support was set out the relief that the applicant was seeking at that stage, which was set out substantively at paragraph 20 on page 116. and it was that the monies be paid, trustees of the pension be directed to pay drawdown funds to the applicant. At the hearing, the respondent.
I mean a direction by a creditor to the debtor to pay money to a third party is an assignment, isn't it?
So certainly an equity, and if it's in writing in law as well, I would submit. Yes.
Yeah, it's certainly an equitable assignment.
Yes.
And as you say, if notice is given,
Yes.
it's a legal assignment.
Yes.
So I mean, even looking at that, at what was said to be sought in paragraph 19 and 20, particularly 20. I think if you were trying to analyse what the effect of the court order would be when implemented, it would be an assignment.
Yes. I would adopt that, my lord. Of course, things moved on in the sense
They
that...
did,
Yes.
because presumably somebody might have actually spotted that.
Yes. Well, of course, up until the... I wasn't involved below, but from what I understand, up until the hearing before His Honour Judge Hodge, or the days before it when my learned friend filed their skeleton argument, the relief sought changed to meet what Mr Asquith, who was appearing at that stage for the appellant, had to say about Section 91 being a clear... clearly an assignment, as I understand it.
It affects Section 31.7 in the sense that it might be said that the purpose of using an order under Section 31.7 was to avoid creating an assignment, but nonetheless achieve the same effect.
Yes. Yes. Well, that's exactly how we say the two sections are to be read, effectively, my lord, which is that historically the provisions against assignment came in to stop debts being assigned to, or rights being assigned to trustees in bankruptcy in a normal way. Here, Section 91 applies outside as well as inside of bankruptcy. So the Parliament has said, well, we'll prevent assignment, but also we'll stop the court doing it by order, because that's the same
Section
thing.
31.7 has a limitation, which is that the exercise of the order must be just.
Yes.
And if the context to a case suggests that you're trying to find a court order which would avoid something which is otherwise prohibited, it might pose a question as to whether it's just.
Yes, my lord. That's another way to put the argument in my submission. You can say, well, you can't make the order because Section 91.2 stops you. Or you could say it's not just to make the order, because you might read it in a way that does enable you to make the order, such as perhaps the respondents are submitting. But it wouldn't be just to make the order.
With any Section 137 in the public, sort of quasi-public law field, you can't make an order if it would do that which is statutorily prohibited.
Yes.
And then perhaps the less extreme version is you can't exercise the power if it would thwart a statutory regime. That's perhaps less extreme a version. Would probably, I mean, the argument, well, it would be one or other, but it may be the second rather than the first here. If you conclude that Section 91 has a certain prohibitive effect, then a court shouldn't, in justice, be exercising its statutory power to grant relief to undermine what Parliament is intended should be.
Yes. Yes, my lord.
Just, I mean, that's a structural analysis of Section 31.7.
Yes. 37.1.
That's 37.1.
Yes, my lord. As I say, I'd say it's an alternative way of looking at it, which I would endorse. So just going back then to Judge Hodge's judgment, and this point that it was acknowledged that the reframed relief, which was, well, actually okay, and bear in mind, my lady, this was reframed relief shortly before the hearing, and in fact, Mr White's counsel sought to say that the argument couldn't be advanced at that stage. It was too late in the day to be shifting the ground. But His Honour Judge Hodge, Queen's Counsel for reasons of efficiency, and he considered it was fair enough. The parties were on an equal footing, decided that the point could be dealt with. But again, it was perhaps a situation where the point purely on 91.2, and this question of receipt wasn't as well ventilated as it might have been had that been the basis of the application.
The application notice was never amended.
I don't believe so, my lord.
I mean, it's a slightly unsatisfactory. I know it's often done this way in relation to insolvency matters. And I'm not sure it necessarily should be. But it's a slightly unsatisfactory way of doing it. To say, well, we seek an order in terms that are set out in a witness statement, and then the order actually that's made is not ever, as it were, put onto paper to be the subject of debate, as I understand it.
That's how I understand it as well, my lord. And, it looks that way if you look at what Judge Hodge has to say. Read the transcript which we received on Friday of the hearing. It looks as though the point was being dealt with somewhat on the hoof, in the sense of the submission was, well, as long as you get the substance right, the form doesn't matter too much. And so, in the end, what the order that was actually made, well, there was a subsequent hearing to deal with the detail as well. But the order that was actually made on the first occasion, which there be a drawdown obligation upon Mr. White, was, I think I'm right in saying, something different than what anybody had actually sought.
Yeah.
So, as I say, if you go through the judgment and look at certain paragraphs, it becomes clear that the respondent had always acknowledged, the court acknowledged below, that this was always an order, the idea of which was as set out in paragraph 13 of the judge's judgment, that the respondent should be required to access his pension pot so as to enable him to satisfy his judgment debt. And the mechanics for achieving that were essentially a matter of form rather than substance. So it was always the case that the order made was for the particular purpose of enabling attachment. And that's apparent from paragraphs 13 to 17, from paragraph 23, paragraph... sorry, my lord.
Just would you give the paragraph numbers again?
I'm sorry, so I got as far as 23, I think.
But you'd started at 13, in the middle of 13. It's, it has always, it says, the issue, as recognised by Mr. Asquith, has always been and remains whether the respondent should be required to access his pension pot so as to enable him to satisfy the substantial judgment debt.
Just to be clear, just pausing there, is the judge right? I mean, in the sense that when it says so as to enable him to satisfy his judgment debt, I mean, I think the real point is it wasn't intended that he should have any freedom in the matter.
Correct, my lord.
I mean, it hadn't always been that he should have any freedom, because the point about the order that was originally sought was that, as it were, that the monies would never go to him in the first place.
Yes, my lord.
It wasn't a question that he... I mean, it'll come back into this argument when given Mr. Girl's skeleton, but it was never suggested, as I understand it, that there would be any freedom on the part of the respondent to choose what he did with the money. I mean, because if he had been, what basis then is the order sought in the first place?
Well, why are we here, my lord? Quite.
Yes.
If Manolete don't get the money at the end of it, why is anybody here?
Yeah, I mean, you know, the very foundation for the application to the court to make the injunction was that the judgment creditor wants the money.
And that's really our point, my lord, here. Yeah. And initially it was to go to them directly. Then that form of relief changed. But your lordship's quite right to say, probably wrong to say it was always the case, but more latterly it was a case of it should go to him so it could be attached. And if one looks at the second judgment of Judge Hodge, which I'll come to in a moment, you can see that what was then sought, once that relief had been framed as it would be for him to draw down, what Manolete then said was, well, we want an order that gives us visibility on what's being drawn down into a nominated bank account and we are told before drawdown there was a nominated bank account, say that we can go and make a third-party debt order or whatever, or a freezing order, or a charging order. So it was always their case, in one way or another, that the money was going to them.
Because otherwise, what
Why
business
bother?
have they? Well, what business have they got asking the court to make the order in the first place?
None in my submission, my lord, because the court wouldn't then have any established jurisdiction to make such an order. In my submission, outside of bankruptcy or any other insolvency process, no creditor has a jurisdiction. The court doesn't have a jurisdiction to order people to generate assets to pay their creditors. There's specific parts of the civil procedure rules that deal with particular types of enforcement, and then there's a bankruptcy process for individuals whereby a trustee in bankruptcy is appointed and they have the powers in the Insolvency Act. But there's no power on an individual in my submission, nor for the court to assist it by injunction, to go around to creditors, to debtors, saying, well, you have to, Mr. Moran in the Batchy and Green case used the example of you have to go away and write a book so you'll make some money and we can enforce against that.
But that's what is clear, what you were saying about access to the pension pot, and they didn't mind how the order was framed as long as that was achieved,
Yes.
is set out at 13 and 17.
Yes. Yes, essentially, I think at 13, his lordship was dealing with what the submission was, and then at 17, he's essentially accepting that submission.
A statutory jurisdiction to do that which is just presupposes that you don't allow form to overcome substance.
Yes.
In paragraph 17, the judge says that's precisely what he proposes to do. Substance prohibits something, so I'm going to find an alternative form to achieve that which I can't otherwise do.
Yes, but we say he gets that the wrong way round.
Agreed.
Yes.
I mean, the problem is he's turned section 37.1 on its head. He's allowing form to overcome substance.
Yes, my lord, that's exactly our point.
The substance is that which couldn't otherwise be done.
I should give you these paragraph numbers. They much make the same point. It's the end of paragraph 23 on page A79. Paragraph 43 there's reference again to assisting the judgment creditor in the third line before the enumerated points. Paragraph 51, page 88. The last two sentences there make a similar, this is a submission at this point. Should assist the applicant in recovering the substantial judgment debt. Clearly just and convenient for the respondent to be compelled to use his pension pot to discharge his judgment debt.
I mean, that to pick up my Lord, or Justice Green's point, I mean, the judge is there clearly addressing his mind to whether it's appropriate under section 37 to compel the respondent to use his right to future pension. That's what he means by pension pot.
Yes.
It's not the money which he is actually in receipt of. It's not the money that his bank has in his hands. So it's saying it is just and convenient for the respondent to be compelled to use his right to a future pension.
Yes, I would just differ, my lord,
Or
on
entitlement to a future. It's entitlement to a future pension. In essence.
which paragraph is his lordship looking
I'm
at?
looking at the 51, the last sentence of 51.
Yes.
When he says pension pot, goes back to the point I made to you earlier. He means, does he? I think he means the right or the fund which isn't paid to Mr. White unless or until Mr. White calls upon it to be paid.
Well, it's hard to say, my lord, because we say that's the mistake that his lordship made in the end, which was when he then comes to look at the good report in paragraph 74, I think, he treats the right to call for payment as if the pension was in payment.
And that's why at the very beginning I was concerned to discover what the position is, and I'm still not entirely clear about that. And we were in volume B and looking at the rules, and you mentioned to me rule 6, and 6C being a member's drawdown pension fund. And it seems as if, and I'm sorry to go back to nuts and bolts, but it seems as if the member here was entitled to a drawdown pension fund because he's reached retirement, as in 6A, and that would be that he was entitled thereafter to a payment of a lump sum under 6B and provide a pension payable in accordance with Section 3 of this rule. Section 3 of the rule says that the trustees can secure and purchase an annuity. And then one gets to 6B, which is lump sum, and then you get to 6C, which is a drawdown pension fund, and that's defined at the beginning in a not terribly helpful way. The member shall agree with the trustees the income to be withdrawn from that fund in each year and the number of instalments, etc. And that isn't what's happened here, as I understand it. There aren't any instalments being paid.
No election's been made.
Well, is it an election? That I'm sorry to go back to really basics, because it's 6C1 is he shall agree, and then in 6C3 the member may at any time direct the trustees to use the drawdown pension funds to secure a pension for him in accordance with 3, which is an annuity that should be commenced on a date to be agreed. And there isn't any suggestion that he can elect or not elect there in 6, at least. So that's why I'm slightly confused about what the actual situation was, and that matters in relation to tying it back to entitlement or pension payable.
Yes. Well, in my submission, you see, if a member shall agree with 6C1,
Yeah.
the member shall agree with the trustees the income to be withdrawn in each pension year.
Yeah.
So he could agree to draw nothing in a pension year. He isn't obliged to draw down his pension. And it's never been suggested that he was, I don't believe. The suggestion was that the court could compel him to do it, but he isn't obliged under the rules to draw it down.
Well, probably there is some tax reason, and he can only not do so for a specified amount of time, depending on his age. But that's drilling down to something I expect we haven't thought about in any great detail. But you're saying, as far as 6C1 is concerned, he can agree nothing, and he has agreed nothing. And in effect, the injunction, therefore, is to require him, although this isn't the way it was put at all, I don't think, or require someone on his behalf to agree something for the purposes of 6C1.
Exactly, my lady, yes. It's not
It's all quite muddy, but there we go.
Yes, it's not dissimilar from the situation. Henry Hilton, just forgive my back. Yes, it's not dissimilar to the situation in Henry Horton, which we'll come on to look at in a short while, in the sense of the pensioner there was in a similar position. And I'm just being told by those who have the benefit of listening slightly more readily to the interventions without thinking on their feet, that you're right, my Lord Snowden, to say that the pension pot, we think, is being used by Judge Hodge to mean the right to elect a drawdown and receive payment, if that was what his lordship was doing.
Yes, I mean, the question I was going to follow up by saying is, I think it's your submission in effect that if you look at the last sentence of paragraph 51, that which is said to be just and convenient is for the respondent to be compelled to do something which falls within the prohibition in section 91.
Yeah.
Yes.
And my Lord Justice Green's point was, how can it be just and convenient under section 37 for the court to order somebody to do something which is, as it would, directly prohibited by the Pensions Act?
Or thwarts the principle behind.
Yes.
Yeah.
But broad idea, the statement in broad idea of Lord Legate would say you don't have the jurisdiction to do it in the first place, because if it's subject to a statutory prohibition, then the court doesn't have a jurisdiction to grant. It perhaps matters not which analysis.
It's either no jurisdiction or it's a wrongful exercise of the discretion. It's wrong in law.
If it's not just and convenient, you don't have it might be said you don't have the power to do it, but if you did in theory have the power to do it, you wouldn't do it.
Shouldn't do
It's
it.
just inconvenient.
Yeah.
You can slice it and slice it, and perhaps that's why Lord Justice Mayles sort of basically said, well, I'm not sure I spot the difference between
Yes.
Lord Justice Newey and Lord Justice Arnold on the facts of that case. But in any event, if the pot is synonymous with that which is the subject of section 91(1), then at that point, I think you say that's what the judge failed to spot.
He may have spotted it there, but he
Again, the
didn't
wrong
spot
answer.
it when he came to look at the good report. In my submission, he thought the distinction was between a right to elect and an election and future rights that couldn't yet be claimed. Whereas, as we'll come to look at with the good report, in fact, the good report's very clear. The distinction, as are the other Court of Appeal cases that have followed, the distinction is between in payment and pure rights.
Yeah. So when money is in your hands, if it came from your pension, it doesn't matter. It can be.
Or immediately due. So you'd already exercised the right to elect and it was due to be paid to you. That would be treated as in payment. The authorities don't entirely speak on one voice as to what entitlement means, but it's clear that we're within the right realm because we haven't received and we haven't elected. So then we need to look at paragraph 71 to a similar effect. Paragraph 73, where the respondent's position is noted in the third line, making it clear what was meant was that the respondent would no longer have the ability to spend his pension on himself, but would have to use it to pay his creditors.
Sorry, I've missed where you're reading.
On 73 then.
Line 5 and 6,
Yes.
paragraph 73. And he says that's consistent with the law's policy of ensuring the due discharge of judgment debts. No doubt that's right, subject to
Yes.
occupational pensions being different.
Exactly, Manolete. As I said at the start, we don't dispute that general principle. What we say is that in this case, that general principle gives way to section 91. And that's not a technical reading of 91, that's the whole policy of 91, is to protect occupational pensions from attachment.
I mean, 75, I therefore hold that notwithstanding section 91, I have the jurisdiction.
Yes.
But that's the issue about the relationship between section 37 and section 91.
Yes. 74 is perhaps the crux of the judge's reasoning, so I ask the court to note it. He says 4 lines, in fact 6 lines above the indented part, that it made no difference that the order was motivated by the objective of enabling that pension pot to be applied in satisfaction of pre-existing judgment debt owed to the applicant by the respondent. Well, I respectfully say it made all of the difference. And then there's a bit where he relies upon Professor Good's report. He says the position is of course otherwise, quotes the part that says the position is of course otherwise where the pension has come into payment. So he seems to be treating Mr. White's pension as having come into payment, whereas clearly it hadn't. Apart from anything else, with the lady's point, this was of course not a liquid pension fund, it was a property. So what would need to be done is the property would need to be sold and then any proceeds paid. So it was, in my submission, far from the point of being in payment. The second judgment is at tab 90, page 99 in the main bundle. And I just would note paragraphs 8 to 10 on page 101. So you can see, it makes good the point I made earlier about how at that stage what the respondent was seeking was, yes, it was going to be effectively an order for sale in the sense of trustees were going to get on with the sale with monitoring provisions for the respondent so that they could essentially, in due course, as his lordship then says at page 102, paragraph 13, the third line down, he says, I'm satisfied that paragraphs 3 and 4 of the order were necessary in order to enable the applicant properly to police the order and to ensure that the whole objective of the order is achieved in the sense of enabling the applicant, once the principal asset has been sold and the net proceeds paid to Mr. White, to be in a position to take then the steps to satisfy the judgment debt he has obtained against him out of those sale proceeds.
That's there saying that it will be for the applicant to take steps to seek to satisfy the judgment if debt owed to it.
Yes.
There's no freedom.
No. Well,
but there's just going back to paragraph 9. I mean, the analogies are actually the two frames of analogy. I mean, it's said in the context of a policing provision, but actually the two examples given are quite different, aren't they? I mean, in the sense that a standard form freezing injunction does not give the creditor or the claimant any proprietary interest in the assets of the debtor. It just stops the debtor disposing of his own assets illegitimately. Whereas a standard form order for sale actually is done at the behest of somebody who has an interest in the property. Yes. Those are two quite. It's quite curious, but they're two quite different concepts.
Well, they're almost the opposites, my lord, aren't they?
Because they're conceptually quite different.
The freezing injunction doesn't give you security and assumes you haven't already got an asset, hence why it's frozen.
Yes.
Unless it's a proprietary injunction, of course.
Well, yes,
but here it seems...
It's an old bugbear of mine. People use the word freezing injunction rather loosely to cover a proprietary injunction occasionally, but a freezing injunction, properly so called, is not based on the proprietary interest.
Whereas an order for sale is?
An order for sale is, either because you have an interest in the property, or because you've got a charging order over it, and it's, in other words, which gives you an interest in the property. But here, what's being said is, this is something which the debtor owns, has an interest in, it's an entitlement or right, which the judgment creditor is essentially seeking a mechanism to have applied for in satisfaction of its own judgment. In other words, it essentially is attempting to get some sort of proprietary interest in the asset.
Certainly, puts it a step ahead of other unsecured creditors, because
if as a judgment creditor you can prevent somebody's asset being used by them for their own benefit freely, or prevent it from being used to pay somebody else, it's often the case, perhaps not exclusively, but on the basis of a proprietary interest. And otherwise, I don't understand what basis you're doing it, in the absence of the sort of evidence that supports a freezing injunction of an attempt to frustrate a judgment.
Yes, well,
okay. All right. Sorry, that was a bit of thinking out loud.
I perhaps have to speed up a little though. So I've taken you to that. You can see the form of the order made was as his lordship has aired, and essentially gave Manolete a position whereby they were able to know where the money was going in advance of it going there, and then take steps to enforce. So that takes. I better move on to my second point, which is general principles of statutory interpretation. Hopefully, I probably don't need to spend too long on this because I don't anticipate they're familiar to the court. We cited what in our submission is now the leading Supreme Court case on statutory interpretation generally, which is...
PACAR.
I'm sorry, my lady.
PACAR.
Yes.
PACCAR.
Which, of course, Parliament is just about to reverse statutorily.
Well,
not necessarily on that part, but it fell when Purdah was called, but any new administration of any colour has indicated that it will reverse PACAR.
Well,
but probably not on principles of interpretation, but I don't really think they're in dispute.
No.
We have to determine what the proper purpose is behind section 91 and apply it.
Yes, my lord, and we've directed you in our skeleton argument, paragraphs 34 to 36 of the parts we would draw attention to. Really, the point we draw out of this is it's about looking, as particularly the point made in the UBS and the Uber cases, it's about ignoring intermediate steps that don't affect the substance. And we're back to this point of, well, in fact, it's the very opposite of substance governing form. It's allowing form to govern substance. And we say if you look at the section, it's wrong to construe it in a way that ignores, as we say in our skeleton, to stop the analysis at the point at which the funds reach Mr. White, because that's clearly not the basis on which the order is made and the jurisdiction to make it exist. So I'm grateful for that. I'll skip over the respondent's skeleton argument refers to dictionary meanings, purports to give restrain a single meaning in legislation of the word's ordinary sense. Well, in my submission, that's a wrong approach. In each different instance, the word's meaning comes from its particular context. You can't say a word means the same thing across the whole statute book. That just wouldn't work. For example, a civil restraint order is a completely different sort of order to that which is contemplated by section 91(2). For one thing, one's restraining an active person who's litigating capriciously, whereas 91(2) is a passive restriction.
I mean, the critical words I was focusing on was actually receiving.
Yes.
I mean, in a sense, if receiving means receiving beneficially, i.e. for his own benefit, that's one thing. If it means simply receiving in a ministerial capacity for somebody else,
yes,
that can be another.
Yes.
Which of the two do you say?
Well, we say it's ministerial. The respondent says in their skeleton argument, I'm not sure of the paragraph now, they say we accept that Mr. White receives his pension beneficially. We don't. We say he receives it ministerially. The effect of this order.
The answer to my question actually was the other way around.
Yes.
I think you say you can't be stopped. The order can't stop you receiving it beneficially.
Yes.
Yes.
Yes. And so what we say is the effect of this order is we receive it ministerially, so and ultimately, therefore,
not.
Yes, we don't receive it beneficially.
Right.
Yes, exactly.
Yeah, because you are, this point which we'll be asking Mr. Curl about, but you say the effect of the order is that he isn't free to dispose. It's plain viewed in context that the order prevents him from taking steps to dispose of the assets.
Yes.
The monies when received into the bank account.
The respondent says, well, Manolete might not enforce against it, but that's unrealistic in the same sense as in those cases that I took you to.
Well,
in statutory interpretation, you look at what's the realistic outcome of realistic acts that you're construing it.
Well, I'll ask you. Did you say it would be a breach of the order, or it was plainly not contemplated by the order that Mr. White could, for example, spend the money the instant it hit his bank account?
Well, in all likelihood, under the order, he wouldn't get the opportunity because the order requires prior notice of the money hitting his bank account to be given to Manolete, who at that stage, I assume, would seek some kind of order, whether it's a freezing injunction or something else. So or maybe a third-party debt order against the pension at that point, because of course there's the cases where the court has said you can't get a third-party debt order until the pension's actually been drawn down because there's no debt, or until you've elected and it's immediately due because there's no debt until that point. So perhaps at that point they'd seek a third-party debt order.
But the purpose of the Section 37(1) order was to facilitate further steps to be taken in order to prevent those funds being allocated to the appellant. In
which case he would be in contempt of court perhaps if he went ahead and spent those monies when they hit his account.
Well, that's the sort of question I'll put on the table now so people can think about it is, suppose Mr. White just executed a trust deed which would settle the monies when received instantaneously on trust for his family or Battersea Dogs Home or whatever. such that the instant the monies were received into the bank account, they would be impressed with the trust. If that is presumably not, that's precisely not what Manolete would wish to occur.
No.
And the attempt to do so to frustrate any order that they might seek would presumably be said to be a breach of the intent that lies behind this order. Because otherwise, what's the point of all the apparatus in it?
Yes.
Anyway, it's in a sense that's not for you necessarily. I mean, you say the effect of the order is clearly to stop him receiving the pension beneficially.
Yes, my lord. Exactly. And my immediate answer would be
The purpose had that effect of the order. That was the purpose behind the order, was to have that effect. Quite how it would happen, no doubt. There is further material to add to that void, but that was the purpose behind the order. That's what it says in all the paragraphs you read to us.
Yes. And you can see if you look at the order, the notice was to be given at every stage of the sale process of the property. At each stage, which would enable Manolete to take steps. And my immediate answer, my lord, is no doubt they'd say it was contempt of court. Whether the order has some other effect, I'll give some thought to. I'll just go back to dictionary definitions, as the court no doubt knows, aren't a helpful aid to construction because a dictionary collates attested uses of words. It doesn't purport to identify the meaning of a word in its context. And so very often...
I think they're admissible, but they're never binding. They're valuable and helpful, but they don't necessarily paint the whole picture.
I think they've been described, my lord, as the last resort of a baffled judge.
Oh dear, I've just given the judgment using dictionary definitions.
Well, I'm sure it wasn't meant to apply to you, my lord. That was an American judge, I understand. Anyway, so we know where American judges stand at the moment. I've just returned then, my lord, to the point about restrain and receive. Yeah, so it's slightly different, isn't it? Because what we say is the effect of the order is he received the pension, or he will receive a pension in a ministerial capacity. We say that that's a breach because he isn't receiving it beneficially, which is how he should receive it under the statutory scheme. And that's been recognised that that's the effect of these orders. In this case, paragraph 73 of the judgment, for example, by Batchy in the Court of Appeal and in the High Court. And we go back to the point of it's all about the jurisdiction. And the jurisdiction only exists to enable it to be enforced against. So it presupposes that the receipt is ministerial only. And we made some points about that, paragraph 43 of our skeleton argument as well. So, come on to my third point, the correct interpretation of section 91. I'd invite the court to look at the section which is at tab 7 of the authorities bundle, is in its existing form, which is the form it was in at the time of the order. We've included for completeness other pension scheme acts and also the form of the act as originally enacted. With tab 7, page 38 of the authorities bundle. And start by noting the title of the provision, which is inalienability of occupational pension. And we say, well, that's what it's all about, different types of alienation and prohibiting them. Subsection 1 sets out restrictions on dealing with the entitlement or right, and essentially, my lady, it prevents the pensioner doing anything at all to deal with his pension rights.
Is the list in 91.1a to C intended to cover everything which would create inalienability?
It seems to be, in my submission, my lord, it seems to have attempted to cover off, even set off, which seems to be the sort of, is the last of them. And so any right to assign, commute, surrender, all of those are quite broad, of course, in application. Well, a particular commuted is broad, assigned and surrendered perhaps narrower.
And there's a prohibition on charging or the exercise of a lien.
Yes.
And the prohibition on a set-off.
And any agreement that has the effect of doing any of those things.
And then, yes, which has the effect. So you look at the effect of those, and anything contractual which would lead to the same consequence, assignment, commutation, surrender, etc., is unenforceable.
And presumably received, the word receiving has to be interpreted in light of presumably what went before in sub 1.
Exactly right, my lord. I say
all of those things prevent beneficial receipt, I think. If you assign the entitlement or right,
Surrender it or
commute it, you execute a charge over it. In a sense, you would still receive it legally, but it would be not receipt in a beneficial capacity, because it would be receiving ministerially for the chargee. Chargee.
And receipt by set-off would include a court order enforcing the set-off.
yes. Likewise, you could have a charging order. So in my submission, it looks as though the draftsman has sat down and sought to think of every possible way one might divest themselves of their pension rights, or someone might purport to, in the case of a lien, purport to exercise a right over it, and prohibited those things. And of course, we say one of the main gap in the respondent's case is they don't identify competitors to this. They don't say, well, no, what this section is all about really. They just say, well, you need to look at the words receive and restrain in isolation and give them a linguistic meaning. So yes, we therefore say subsection 2 needs to be read in light of subsection 1 as effectively being to prevent the court from doing anything to the equivalent effect of what's in section 1. The other point we want to draw attention to, my lady, is in subparagraph 2, the words the effect of which. Because it would, of course, been possible for the draftsman to simply say no order can be made that would restrain the person from receiving that pension. But they've chosen the formulation, no order can be made, the effect of which. In my submission on normal statutory interpretation principles indicates that those words are to be given a meaning, and the interpretation is to have a regard to the fact, to every word. And not,
they're anti-avoidance, really.
Yes. But in my submission, they emphasise the breadth of the section.
Or to put it another way, to cover substance, not just form.
Yes, my lady. Were those words not there, for instance, one might say, well, it would stop a freezing order, which actually restrains you from receiving it, but it wouldn't stop an order like this one because you receive it and ministerially, so you've received it. The words the effect of which, in my submission, put it beyond doubt that the formulation chosen by the court below doesn't get around subsection 2, because it's an order the effect of which restrains receipt. And so we say the combined effect of these provisions is, as the section heading suggests, to prevent alienability of occupational pension rights. And subsection 4, of course, doesn't contains an express carve-out, for attachment of earnings and income payments orders. So one can see that there's a need to carve out those two, which wouldn't be necessary on the judge's formulation of subsection 2, certainly in respect of income payments orders that are paid to the bankrupt, but it would be a bankrupt in that situation first. We deal with that at paragraphs 44 and 46 of our skeleton argument. Next is the good report. We've quoted really the key parts of the good report in our skeleton argument, the key parts that we rely upon. It's at the end of the bundle, it's tab 32. And it's important to note it's dealing specifically with occupational pension schemes. And page 551 of the authorities bundle, paragraph 4.14.1, sets out the issues that are being dealt with. And at 4.14.3 and 4.14.4 on page 552, it deals with the objectives of the prohibition against dealings with pensional entitlements. And it says
4.14.3
and 4.14.4. I'm afraid 4.14.3 hasn't been highlighted. But perhaps put a mark against that one if you will, my lady. And it says about, secondly, 5 lines down, and more fundamentally, the purpose of a pension scheme is not to build up an assignable asset, but to provide income to support members upon their retirement, to their dependents on the member's death. The state has an interest in such provision, for in its absence, the state itself may have to provide the requisite retirement support. So that's the principle that was identified by the Good Report, the purpose that was identified by the Good Report. And then paragraphs 4.14.3.3 to 4.14.3.5, which we've quoted in our skeleton argument, make clear not only that purpose and prohibition against attachment by individual creditors.
Just before you go to 4.14.33, that's right. Do we not need to go via 4.14.20 and 21 just to see the whole picture?
Yes, my lord. Sorry, my lord, I'm speeding up a little bit because I've one eye on the time.
But that's part of the whole, isn't it? About sort of making these future pension rights, as opposed to pension payments themselves, not treated as a bankruptcy asset. I'm looking for 4.14.21 specifically.
Yes, my lord.
I mean, that's the distinction that you say the judge got wrong.
Yes.
So and there is another decision of Judge Hodge we've seen in the bundle, but about the question of whether when you're looking at bankruptcy, you take into account future pensions rights.
Yes, my lord. It's sort of a logical extension of the order made in Blight and Brewster, except that Mr. Moss, QC, didn't seem to have in mind that a debtor wouldn't be able to make themselves bankrupt, because he says, well, if they want the protections of bankruptcy, they should make themselves bankrupt. Well, Shaw, which comes later, then says, well, you can't make yourself bankrupt. If your pension's sufficient to pay your creditors, you can't make yourself bankrupt because you could draw down your pension. That creates, in section 91.2, occupational pension territory, we say creates an absurdity. Because it's happenstance whether you have £1 more or less when you owe your creditors, whether you lose your pension or not.
The whole point about this is occupational pensions as opposed to any other sort of pensions.
Yes, but
occupational pensions just seem to have this very specific and privileged position for the reasons perhaps as you identified set out in 4.14.3.
Yes.
I mean, I'm not.
And one can see why an occupational pension might have a slightly better status than a personal pension, and in any event, that's just the position. Parliament's legislated for one outside of bankruptcy, not for the other. So going to 4.14.33, my lords, you have the point. I think, again, all the language is about the distinction between income in the hands of members, i.e. in payment, and future pension entitlements or rights to draw down. And it says at 14.35, it doesn't preclude attachment once the money is due for payment or paid over, but it does prevent it in the case of rights. Now, the Good Report has been relied upon to construe section 91 in various cases.
Again, the justification in 4.14.34 is a sort of partial answer to, or an answer to Mr. Moss, or his argument.
Yes.
But in the context of occupational pension schemes.
Yes. Well, in my submission, what Mr. Moss said, it could be right. If it was possible for the debtor to make themselves bankrupt with an occupational pension and then get the right to the protection, then his logic would seem to follow. If they can't do that, then it creates an absurdity in my submission. Now, whether he would have dealt with that situation in the same way if faced with those facts is not clear, but given how he expresses himself, in my submission, I infer that he wouldn't necessarily have dealt with it in the same way. And is perhaps the answer the opposite, which is that if a creditor wants a debtor to draw down assets and do all sorts of things that they can do in bankruptcy, then they have to commence bankruptcy. And then, of course, it would be protected in any event in bankruptcy. Going to move on to umbrella trust, Manolete. Umbrella trust is at tab 20 of the authorities bundle. This was a case about attempts to transfer pensions contrary to section 91(1. So the facts are not especially pertinent to the facts of this appeal or the issues, but the statements at paragraph 45 and 46 is where the good reports relied upon to the same effect that we seek to rely upon it. And the key part of Mrs. Justice Rose's decision, as she then was, is at the end of paragraph 46, where she talks about the policy of section 91, and there she's dealing with subsection 5. Well, in fact, she's dealing with section 91 and 5 being an exception to that general policy. And this expresses the policy as the state having an interest in ensuring that funds built up in pension schemes are used to make provision for members on their retirement and dependents on their death. There are 3 further Court of Appeal cases that refer to the good report in interpreting the Pension Act 1995, from which we submit the statutory purpose of protecting occupational pensions from enforcement by creditors emerges. The first in time of those was Krasner and Dennison, which is tab 16 of the authorities bundle. This was a case dealing with personal pensions in bankruptcy before implementation of the I've got the acronym, let me remind myself.
It's
the Welfare...
Yes, the pre-1999 Act.
Yes, my lady. So, pension, that was the context, personal pension. Inri Landau had established that personal pension rights vested in a trustee in bankruptcy in that situation, which was subsequently reversed by the 99 Act. The court held, therefore, that payments received after bankruptcy pursuant to a pension rights in existence at the time of the bankruptcy, as opposed to in payment, which Lord Justice Chadwick notes at paragraph 3 in relation to what was not in payment, where an election hadn't been made. That's paragraph 3 just below letter B. The court held that those payments fell within the estate, the bankruptcy estate under section 283. Therefore, they didn't need to be and could not be subject to an income payments order, because income payments orders under section 310 of the Insolvency Act apply to property not otherwise within the estate, such as after acquired property, like income to which was no entitlement prior to the bankruptcy. And that's dealt with at paragraphs 22 to 33 of the judgment by Lord Justice Chadwick, with who the other members of the court agreed. At paragraphs 42 to 53, the court dealt with whether restrictions on alienation within the pensions, because of course there was no statutory restriction, prevented them from vesting in the trustee in bankruptcy. And in rejecting that contention, Lord Justice Chadwick said at 48 to 49 that Parliament recognised the need to protect certain classes of pension benefits from creditors, and where it has thought it right to provide such protection, Parliament has enacted in an assignment of a pension right shall be void. And he takes the reader through some of the statutory history to protections against pension rights, which are often in the form of an assignment, like subsection 1 in this case.
And so this isn't really very helpful to us other than to fill in the background.
Yes, what I say...
It doesn't assist with the position we're in, really, does it?
In two respects, perhaps, my lady. One is in that, again, distinction between payments and rights and what's intended to be executed against and what's not intended to be executed against.
It's the middle of 52, isn't it?
I was coming on to 52, my lady, yes.
Sorry.
No. Happy to... I'll just say the second point, which I think is useful, submit is useful from this case, is it shows the carve-out, where the carve-out for IPOs come from and how that helps to explain why Section 2 has one effect, Section 1 and 2 have, subsection 1 and 2 have one effect, and then the carve-out in Section 4 of section we're looking at has a different effect. And I'm sorry, my lord, yes, paragraph 52, he said Parliament knows well how to provide when it thinks fit, but a restriction and alienation shall not be enforceable. And he then goes on to refer to the Pensions Act 1995 and its protection on occupational pension scheme rights. Does that cover your question, my lord?
Yeah, I mean, that seemed to be the extent we need background on the point. That's an acknowledgement of the special position of occupational pension schemes.
Yes. It's paragraphs 54 to 57, where 67 returns to the question of income payments orders, which is helpful in my submission. And he says those have to be read in the context of the provision that allowed for income payments order subsection 7, or made the adjustment to add in the words under any pension scheme, was implemented by the 1995 Act. So the two, you can see the context, implement the general protection, and at the same time you have the rights, at the same time you have an amendment to the Insolvency Act so that you can seek income payments order. It's clear you can seek an income payments order against actual receipts in.
Yes, so it's a useful guide to the background, but that's all.
Yes, I will move to the next case. My lady. The next case in time is tab 17, Fisher and Harrison. This was a case in which it's not dissimilar in that it was sole beneficiary of an occupational scheme of his own company. And what happened was a freezing injunction was granted over pension rights to the company after a change in management, and later a consent order agreeing to the benefits under the scheme being used to pay the judgment debt. On neither of those occasions was Section 91 cited to the court. And so when it came before Lord Justice Mance and others in the Court of Appeal, they noted Section 91, in particular subsection 2, and took the view that they couldn't have made the orders that had been made below because they'd be in breach of subsection 2 of Section 91.
Section 91 hadn't been brought to the attention of the judge below.
No, my lord. And indeed, even before Lord Justice Mance, it appears it was Section 91(1) that was brought to his attention.
Yeah.
And it was the judge who noticed subsection 2. So having thought again, this was before the court because the parties had gone back to court for the determination of whether or not the scheme rules meant that the consent order had forfeited the right to pension. It's instructive this case in my submission again for the point about the distinction between rights and payments, which is reflected at paragraph 14.
It does appear Lord Justice Mance was in a particularly strong position to be able to make the assertion that the judge wouldn't have made the freezing order if the paragraph of section 91 had been drawn to his attention because he was the judge.
He was the judge. So quite. Although he did say later in the judgment he couldn't really remember the case.
Ignorance is bliss.
So yeah, I take the submission of paragraph 14 that was made on behalf of the... what was essentially being argued was the consent order was fine insofar as it affected payments that had been made because they weren't affected by subsection 2, but it wasn't fine in relation to future rights. And that was the distinction that was argued. Paragraphs 23 to 26 is where, well, first of all, paragraph 17, you can see under the construction of clause 19b, page 168, Lord Justice Mance makes a distinction about halfway down. He talks about the Inland Revenue, why they require such a clause, saying, however, once a pension payment has been made to and received by a pension, it is his own money which he is free to use as he wishes. He may have debts to pay with it, a creditor may be able to execute a judgment against him. But recognising that distinction, that is different from the right to claim payment. 23 to 26, we've highlighted, again drawing the distinction, citing the good report for its policy and the distinction. And paragraph 34 confirmed that insofar as, the last 5 lines, insofar as it, the consent order did cover any future pension instalments, it was accepted that that was only...
Yes, sorry, you said, just trying to flick through, at the beginning of 24,
Yes.
it again highlights the distinction you say should have been drawn.
Yes, my lord. It does it in the context of looking at construction of particular rules, because there's no provision here. That, he essentially is saying, well, the good report drew the same distinction that was drawn in other cases about present rights and future rights. And that informed how it then construed section 19b in its application to those things. Clause 19b, sorry. I'll move to Henry and Horton if the court's ready. Henry and Horton is tab 22 of the authorities bundle. These are all Court of Appeal cases, as I'm sure the court's noted. We rely on this case in particular, my lady, as demonstrating the policy behind section 91 should not be circumvented by an order, because it would, to use the phraseology that Lady Justice Gloucester used, come to drive a coach and horses through what the statutory provisions intended to achieve. The facts of this one were particularly stark, in fact, because the pensioner in question was in the fortunate position of not needing his pension because of the generosity of his wife and family. This is at paragraph 6. So he wished and intended to preserve the entirety of it to pass on to his children on death. And he didn't want to take, he had no intention of taking any income in the meantime. Nevertheless, or perhaps rather because, the trustee in bankruptcy made an application for an income payments order equal to the percentage of the debtor's pension that was presently available to be drawn by him. And that was rejected at first instance by Mr. Engelhardt, Queen's Counsel at the time, on the basis that those were pension rights and were not in payment, so they weren't available to be drawn upon. For the distinction here being section 310 and income payments, of course, rather than subsection 91(2). The issue, in fact, is stated at paragraph 2 of the report.
Sorry, but this is a SIP, isn't it? It's not an occupational scheme, I think.
I think that's right. It was a SIP and another personal pension.
Yeah.
Yeah, paragraph 7.
Yes.
And of course, as I say, this is dealing, my lady, with whether or not there was jurisdiction to make an income payments order under subsection 310(7).
Yes.
We say dealing with the same, although a different context, dealing with the same point of distinction between rights and payments. So whereas subsection 2 prohibits an order against right, we say, section 310(7) enables only an income payment order only to be made against income rather than rights to income. So it's only once your pension is in payment then an order can be made under section 310(7). So it's looking at the same issue in my submission, but in a different way. The issue anyway is stated at paragraph 2. And it was submitted at paragraph 14 by Mr. Sykes of Council, who represented the pensioner. It was supporting, of course, the lower judge's decision, and he said that there is a distinction to be drawn, third line, between pensions in payment, i.e. where an election had been made to draw down some or all, which could be subject to section 310, and just rights. And he submits, his submission is recorded about halfway down that paragraph. There's a sharp distinction drawn by the legislation between rights under a registered pension scheme and protected from creditors, income which was not protected. Income meant an actual receipt of money or an unqualified right to such receipt. Did not mean the pension rights themselves. Paragraph 21, Her Ladyship recognised, referred to section 91, and that doesn't prevent the making of an income payments order. Paragraph 31, Her Ladyship made reference to the explanatory notes to section 11 of the 99 Act, again drawing out the distinction made by the Good report or between pension rights and pension payments. It says, of course, those only apply to occupational pension schemes, and then deals with the policy behind introducing similar rights in bankruptcy for all pensions, or for personal pensions. Her Ladyship's discussion of the arguments that were made before her begins at paragraph 35, and she analyses the arguments that were made as to why an income payments order could be made against mere pension rights, so as to compel the bankrupt to draw down their pension so an IPO could be made. She analyses two possible ways of looking at that. One of which was that the trustee was saying, well, under section 333 of the Insolvency Act, a trustee can require the bankrupt to do all such things as might reasonably be required for the trustee to carry out their function, so that that could be used to compel the bankrupt to draw down his pension so that the trustee could make an income payment order against it. It can be seen, my lady, in my submission, that's a very similar argument to Manolete's in-principle argument, which is that they say, well, Mr. White should be compelled to draw down his pension, receive it, and then use it to pay creditors. That was said in the court below to be the justice of the case, that he should do that. And in their skeleton argument, that's the equitable thing to do. There's a very similar argument in my submission to the argument made here, the section 333 argument, which was rejected. The Court of Appeal concluded that compelling the bankrupt to crystallise his pension scheme would drive a coach and horses through the protection afforded by the legislation at paragraph 38, just next to letter H. And it talks about the effect of an order, very similar to the effect of the order that was made here, being requiring the bankrupt to enable a right to be turned into a payment so it could be enforced against. Paragraph 39, the court referred to Blight and Brewster, and the counsel for the trustee in that case had relied upon Blight and Brewster to say, well, you can make such an order, look at what happens. The court said, well, that's a different, it doesn't support the position post-bankruptcy. Notably, the court also didn't accept, or the court's position was that they assumed, this is footnote 3, assumed for the purposes of the judgment without deciding that the decision in Blight and Brewster was correct, no argument to the contrary being presented in this case. There was a distinction, of course, in that Blight and Brewster was a personal pension and this is an occupational pension, so there wasn't section 91(2) to think about. In my submission, reading Her Ladyship's reasons, she would have drawn the same conclusion about subsection 91(2) if it were an occupational pension, as she drew about an income payment order, section 310(7), in the context of this personal pension. Paragraph 41 turns to the second argument posited by Justice Gloucester and sets out her conclusions there on that one.
So paragraph 40 is probably 41.
Yeah, this one.
I mean, that's... Yeah, this is really focusing on the point in a bankruptcy, isn't it?
Mm-hmm.
Yes, my lord.
Yeah.
So it's a personal pension in a bankruptcy where Section 91 wasn't cited for any principle. But I say the point is similar in the sense of what's being asked for here is an income payments order, despite the fact that Section 310 only allows income payments orders to be made. Yeah, that's the point. So I say...
It's the use of one step in order to be able to achieve another, which one can't otherwise achieve. And you say the analogy, although it's in most respects removed from these facts, is the same because you're seeking an order to achieve something which you couldn't otherwise achieve. That's the point.
Lady. And it does have a further advantage that it is fundamentally dealing with a distinction between payments and rights in bankruptcy of pensions. Payments and rights, of pensions.
And over the page, which is her the second argument, which she also objects,
Yes.
In paragraph 42, just below B, contractual right to elect by service of a notice on the pension provider to receive a lump sum or income payment in the pension context is very different in character from the actual payment or the right to receive the actual payment once the relevant election has been made. I.e., if you've got money in your hands, that's one thing. If you've got a right to elect to have money in your hands, it's a different thing. You say that applies here, but I'm very concerned and sceptical about Rule 6C, but we'll come back to that.
Yes. I say that there's an important reason for that distinction as well, which is that once it's income, the debtor's protected by the fact that it can be attached by an income payments order.
91.4.
Yes, and that has the protection, my lady, that the court then has to assess, well, what are the income needs of the pensioner so that they still get some pension that covers their own income, their own expenditure.
Whereas you say, if this were right, it takes the whole, and that's contrary to public policy, and the person is thrown on the state, whereas they've had tax benefits in putting their money into a pension scheme.
Yes, my lady. And those tax benefits were not intended for creditors to have the benefit of.
To enjoy.
Yes. And in fact, in my submission, that then also comes out from her ladyship's judgment in this case, as she goes on later and talks from paragraph 47 onwards about the difficulties of making an order compelling someone to draw down, because where does the principles, she says rhetorically, how does the court determine what we should give by way of annuity, what should stay by way of what should be allowed to be enforced against? She says if you are making an order compelling someone to draw down their pension, the court needs to address all of those things, which it doesn't have any machinery to do. It has machinery to deal with what to make in terms of an income payments order and how to exercise its powers there, but doesn't have anything similar. And this case is a good example. So rather than being bankrupt or rather than having an income payments order made against him whereby Mr. White would still be able to draw on his pension to support him, the whole of it goes. And that is exactly the opposite in my submission of why the pension existed in the first place, why it was given tax relief, and therefore why Section 91.2 exists, or Section 91 as a whole, in fact. And it's in my submission, a very clear statutory scheme, what the Parliament has done. It's protected those things subject to the possibility of income payments orders and attachment. Paragraphs 42 and 44, just going backwards, deal with the distinction again between rights and payments. I would, in my submission, say that we are clearly under the scheme rules in a situation posited by her ladyship in paragraph 42, in the part that my lady referred to. there's been no election made. And therefore, whatever the scheme rules may say, it's not an actual payment that's been made, and no one's suggesting that there's a present right to payment. In fact, the whole nature of relief sought is that we go ahead and do that. Just finally on Henry Horton, paragraph 53, again, goes back to the distinction and to the good report. So, summarising that the third section of my submissions, you have there 3 Court of Appeal cases, which in my submission all support our interpretation of subsection 91(2) as against the good report. They show how the good report justifies or what the purpose of the provision is, which is consistent with the words in their context, and therefore show why the order shouldn't have been made in this case. Just on my fourth topic, the application in this case, the occupational pension scheme was established and held the property for more than 10 years before the liquidation of the company, and the judge noted that interval of time, paragraph 77 of his judgment. So it was a fairly typical self-administered occupational pension, nothing to suggest that it's not exactly the type of pension that Section 91 was implemented to protect, and nobody suggested otherwise. It was accepted. It was an occupational pension. We say at the time of the judgment and order, Mr. White hadn't elected to draw down his pension, so on any view it's not in payment. I know your ladyship might want to come back to me on that. With respect, the court below appears to have misunderstood the distinction between rights and payments, and hopefully those cases have demonstrated where that mistake was made. Ultimately, the order interferes with Mr. White's right to receive his occupational pension in due course, and therefore offends Section 91. Therefore, it's not just inconvenient to make an order. Fifth and final section of my submissions is on the authorities that might suggest the contrary, including the case below.
They're all lower court cases, aren't they?
With the yes, they are, with the exception of Batchy and Green, but of course wasn't on point because Section 91 wasn't argued in the Court of Appeal in Batchy. Indeed, it was conceded in the lower court. So you have Batchy and Green, first of all, at first instance, with Mr. Hochhauser, King's Counsel. His reasoning was it doesn't have the effect of restraining Mr. Green from receiving his pension. It does the precise opposite. Ensures the payment is effected rather than remaining trapped in the fund. Well, in my submission, that's exactly the point. It should remain trapped in the fund. That's the statutory scheme. So that reasoning, we say, has a superficial attraction, but can't stand against a proper understanding of and a proper interpretation of a good report and a proper interpretation of the Act. And if that's not right, then what mischief is Section 91(2) directed at? It's difficult to conceive of it, and nothing has been identified. As I say, Batchy and Green is the next one, Court of Appeal, wasn't argued. In my submission, it's clear from 16H. I think I already took the court to this submission, in fact, that the court might have decided the issue differently had it have been aware of the statutory restriction, had Section 91(2) been put to it in terms, because the reference of Lord Justice Newey is to what Lord Leggett says about no relevant statutory restrictions. Well, if someone had put to him, well, hold on, there is a relevant statutory restriction. Taking the other authorities then in the order that they were decided, Blight and Brewster is at tab 19. Of course, it's a case that establishes the jurisdiction. It was a personal pension. Again, it was a fraud case. Paragraphs 58 to 78 is where the court deals with the defendant's pension. And I've already dealt with this point during an intervention. Our submission is, it's clear from 71, paragraph 71 of the decision, that it's premised on the absence of statutory protection of personal pensions outside of bankruptcy. It's also premised on the debtor being able to make themselves bankrupt, which Shaw has shown may not be the case. Going to Shaw then, which is at tab 26, the authorities bundle, His Honour Judge Hodge below, despite having been the judge also in Shaw, didn't find much assistance from Shaw. He says that at paragraph 26 of his judgment. Essentially, as we say, well, it was really just a logical extension of Blight and Brewster. If it was an asset that could be attached, then it had to be counted for cash flow insolvency. But we say it undermines Mr Moss, Queen's Counsel's premise at 72, because it shows that you can't necessarily make yourself bankrupt and creates the absurdity we talked about. And it's clear that Mr Moss didn't consider that absurdity. Had he been faced with it, or an occupational pension, or Section 91, he might have decided the case differently. He'd said for the respondent that, well, the absurdity exists in relation to personal pensions, so why shouldn't it exist in relation to occupational pensions? Well, of course, the court's duty is to avoid creating absurdity by its interpretation of legislation. It's for Parliament to ensure that legislation generally doesn't create absurdity or deals with any absurdity, and for whatever reason it's chosen not to do so in the case of personal pensions, but it has done so in the case of occupational pensions. Lindsay O'Loughlin at tab 27, another High Court case. It's another fraud case where like was followed. Section 91 wasn't relied upon by the respondent, who was a litigant in person. So it doesn't take us anywhere in my submission. So whereas there's been said to be a consensus of judges and practitioners, hopefully through our submissions we've demonstrated that actually the present case is the only one in which Section 91(2) has been fully argued, and we hope becomes clear that it does prohibit the order that was made in this case. Section 91, in conclusion, protects occupational pension rights, including under Section 91(2) from court orders, from alienability, whereas income received from such pension is subject to attachment in the usual way. And as Lady Justice Gloucester says in Henry and Horton, that's where Parliament's chosen to draw the line. The order below contravenes subsection 2 because it turns an entitlement into a payment for the purpose of attachment in exactly the way that the trustee in bankruptcy sought to do in Henry and Horton, to turn an entitlement into a right to payment so that he could obtain an income protection order. And that's the very thing that subsection 2 is there to prevent, in my submission. My lady might want to come back to me on the scheme rules. And I might ask to take a moment or two to consider any of that, but subject to that, those are our submissions.
Thank you. Thank you very much. Mr. Carl.
Thank you, my lady. My lords, there will be three aspects to my submissions this afternoon. Firstly, I'm going to make submissions to the court on the statute, what section 91(2) says and why it says that. Secondly, I'm going to make submissions on the important differences between the position in a non-bankruptcy case, such as this one, and the position in bankruptcy, which we submit is very different, and my learned friend's reliance on things that have happened in bankruptcy cases is simply beside the point. And thirdly and finally, I'm going to address some errors in the appellant's analysis. So firstly then, the statute. Why section 91(2) says what it says and the purpose behind it. If I could start by taking the court to the provision. It's in the authorities bundle at page 38. Section 91(1) sets out things that the beneficiary can't do, the pensioner can't do. Section 91(2) sets out things that the court can't do. And I agree with something that my learned friend submitted right at the beginning of his submissions. My learned friend submitted that 91.1 says what the pensioner can't do, and that analysis informs section 91.2, which are the same things that the court cannot do. So 91.1, what the pensioner cannot do, informs 91.2, what the court cannot do. Plainly, the pensioner isn't precluded from drawing down their pension when they have present rights to do so. And they're certainly not precluded from spending the money once it's in their hands on paying their debts.
Could a person, the beneficiary pensioner, call the person what they are, could they give a direction to the trustees to pay money to a designated third party? To say, I have my entitlement in the future. Don't pay it, as and when I draw it down, don't pay it to me, pay it to Mr. X.
That sounds very like what happened in Fisher and Harrison, the case before Lord Justice Mance, and that was not permissible.
Because that's an assignment, isn't
It would seem so, my lord, yes. Happily, though, that isn't what the orders under appeal in this case do.
Eventually, well, that was what was initially sought.
Yes, but this appeal is from the orders that were made by the judge.
I appreciate that.
Yes.
But that is what originally the order, such as we know it, to have been in paragraphs 19 and 20, originally sought to do, isn't it?
My lord, at the time the short answer is yes. Just to put a little bit of flesh around that, at the time the application was made, we didn't know it was an occupational pension scheme. And we subsequently got a degree of disclosure from Mr. White and realised that it was. And hence, the orders that have been made in a form based on our submissions and based on the judge's reasoning that do not offend Section 91.
So you say the form of the orders gets round the substance.
Both the form and the substance of the orders do not offend Section 91.
Right, well, it's the second bit, obviously, we're more interested in, because
yes,
obviously, if the substance of what the orders actually made do was the same as that which was originally sought, then you've got a problem, haven't you?
I would if they did, but they don't, my lord. And that is absolutely front and centre of the submissions I'm going to make to the court this afternoon.
Just to be clear, we're all on the same page, yeah?
Quite so, my lord, quite so.
And before we go any further, also,
Yes.
91.1 says these things cannot be done, A, B, and C, and an agreement to affect any of those things is unenforceable.
So it is, yes, my lady, yes. There's no agreement to affect any of those things, and the court order, as I will expand upon this afternoon, the court order doesn't have that effect either.
Okay.
That was its purpose, though, as we've seen from the judge's own judgment in multiple paragraphs. You know, we started with an order which you now recognise was an assignment, which would otherwise have been prohibited, and the judge said, OK, I think obviously this was the argument, we can get round that. And isn't that the problem? We can get round that by exercising a power under section 31.7 in a particular way. And isn't that part of the difficulty? The starting point was transmogrified into the order under section 31.7.
The purpose of the order is to compel the debtor to receive his pension. And that at the moment is the only effect of the order. So whatever my client or any other creditor might do in the future is, in my respectful submission, not part of this appeal, or it shouldn't be part of this appeal, because all that's under appeal is the orders that the judge made, and those orders compel the debtor to receive his pension.
What business has your client got of asking the court to make any sort of order if it's not going to receive the money?
Because the orders were made in support of my client's evident right as a creditor of Mr. White, and the orders will, in due course...
You can't as a creditor just you can't, it's well accepted, you can't, for example, as a creditor, get a court order that says this debtor who is currently sitting on his backside at home has to go out and earn some money.
No, and these orders don't have that effect. What these orders do is these orders have the effect that the debtor is compelled to draw down, and a fund will then exist against which my client or any other creditor...
In other words, it's an order that he has to go out, he has to do something to obtain a piece of property, a fund, a payment.
Well, it's exercising a right. It's exercising a right that will cause something then to happen, and that is a very well-established jurisdiction from the Blight and Brewster line. So, my lord, if that is an objection to Judge Hodge's orders that are under appeal, then that's an objection to the entire line of authority, and it's not suggested by Mr. White that line of authority is wrong. It's just being said that Section 91, that's the solitary ground of appeal.
Yeah.
Section 91 precludes a Blight and Brewster order, not that a Blight and Brewster order can't be made.
No,
so yes, so the Section 37(1) jurisdiction is being brought to bear on Mr. White to draw down his pension, not alienate it, do the opposite of that, and then once a fund exists, my client or any other creditor who wants to be heard on it or make an application for an attachment can seek attachment against that fund.
Could Mr. White execute a declaration of deed of trust, which would bite upon the monies immediately he receives them, so that they thereafter are not available for execution because they're not settled on trust?
Well, the obvious answer to that, my lord, is that would be a pretty extreme Section 423 transaction, because he knows that he's got creditors who are going to make a claim against that fund. He couldn't be on more notice that someone is likely to seek attachment to that fund.
But that's an anti-avoidance provision. I mean, as a matter of this order, are you saying he could or couldn't do it?
Within the four corners of this order, at the moment, and subject to having another think about it over the short adjournment, I don't see that offends the orders that are under appeal today. But it would bring into play other strategies such as Section 423, and it would probably be fit for summary judgment. I mean, the Section 423 application in those circumstances would probably be no more complex than the application to attach the debt that we are going to have to make if we ever want to attach the debt, for no attachment has yet been made.
The whole purpose, the whole purpose of your interest in this is to create a fund against which you can levy execution attachment.
That's certainly our motivation in bringing this litigation, yes, my lord. That's the opposite of alienation.
But so to be clear, what is the basis upon which you ask the court to exercise the Section 37 jurisdiction? I know what the answer would be, but let's just be clear about that.
Yes, we're a creditor of the debtor.
Yep.
We would like to be paid. There's a well-established jurisdiction to compel people to receive their pensions, i.e. not to alienate them, but to compel them to receive them in order that they may then be available for subsequent attachment, which hasn't happened yet. But we asked the court to come to our assistance as a creditor on the footing that it is equitable for people to pay their debts, and it's just and convenient for the court to assist creditors in the course of ensuring that they do so.
Okay.
So it really does boil down to the word effect in Section 91(2), because you accept that you want a drawdown, which is then a target. You accept you can't have a drawdown and an order to pay. You've got to simply have a target. The judge agreed with that and said, I'm going to create this target for you, and I know that the effect would be that it will restrain the appellant from receiving his pension.
Up until the last few words, my lord, I was...
But that's everybody's purpose. That's the explicit purpose behind what you've said. you want the judge to order the creation of the target, and then you will make the application pretty much instantaneously because you're on notice, so that he is then restrained from being able to receive his pension. And that's the edifice which is being set up. I'm not saying it's right or wrong,
Yes.
but that is everybody's, well, your purpose and the judge's purpose.
But you're just saying that's not the effect of this order. It's the effect of what the order makes possible.
Yes, it's the effect of something that might happen later. But, my lord,
That's the real crux of this issue.
Yes, it is.
What might.
It is, my lord. My lord, on your lordship's scenario that your lordship just summarised,
Yeah.
the bit where I part company from your lordship is that he is restrained from receiving his pension because on the facts as outlined by your lordship, the debtor has received his pension. But that is...
That's understood. So actually I'm wrong. It boils down to the difference between would be and will. He would be restrained because he's not, theoretically, he's got a scintilla in time in which he can grab the money and run. If it had been a will be restrained, then that's the essence of what you're saying. He's not actually restrained because there is this theoretical scintilla in time in which he can apply.
My lord, whether it's a scintilla or whether it's a period of weeks while the court adjourns our application for an attachment,
And probably freezes the fund.
and probably freezes the fund in the meantime, but that doesn't mean he hasn't received it,
Yeah.
and it certainly doesn't mean he hasn't beneficially received it.
No,
It means he's got an asset that belongs to him that he has received by definition, for otherwise it couldn't be frozen, that is subject to a freezing order. And my lord, it's most unlikely to be a scintilla of time because in order to get an attachment, at the risk of stating the obvious, I've got to make an application, or my client has to make an application under CPR Part 72. There'll be an interim order made, and then there'll have to come back and be a hearing on notice. And as the court will be well aware, at that hearing, that final hearing, the interests of other creditors will be taken into account, the interests of the debtor will be taken into account, and the debtor, sure as eggs are eggs, the debtor will be at that hearing and making submissions about why it would be unfair either to him or to other creditors.
Understood that.
Yes.
So it boils down to this, rolling it down further and further. If the judge had said an order which was A, drawdown, B, freeze, C, pay to creditors, that would be a breach of the Section 912. But since he's only done the first of those three stages, albeit that it's contemplated that stages 2 and 3 will happen, that's not.
I'm not going to concede on my feet that any hypothetical form of alternative order would have offended Section 91.
But isn't that what you were after?
Yes, and it wasn't granted by the judge for the reasons that the judge has given, because he was concerned that would offend Section 91. So the orders that have been made are the orders under appeal, and they do not offend Section 91. The court has to construe this statute within the permissible bounds of interpretation, as it was put in Quinterville, cited in Packard. Now, it is simply not possible, in my respectful submission, to interpret 91.2 in the way that the appellant does. It's not possible to interpret an order that compels someone to receive something as an order restraining him from receiving that same something. It just cannot be done. If the court is
Technically, I'm sure we can see that. The question is if that's what Section 91.2 is limited to.
Section 91.2, in my respectful submission, cannot be concerned with things that the court hasn't done and might never yet do.
But on the judgment intends to do in some way, shape or form. He's setting up stage 1 of a 3-stage process which would lead to an infringement of Section 91.2 if it were done in one go.
So you're saying, in effect, that this is all premature, because if there were to be a complaint based on Section 91.2, it should be further down the line when there's been a freezing order and an attempt to make, perhaps, an attachment. at that stage, you could put all the orders together and say, is this 91.2? But you're saying now, because we're at the first hurdle in relation to that, there's nothing on which 91.2 bites. I know that's not what you're saying.
I wouldn't want to say anything that might give the green light for further application in the future. But, my lady, what I would say is that one cannot assume a further step or a further 2 steps will be even taken, let alone granted by the court, when construing this first order, which has been made with a very particular function, which is to compel Mr. White to receive his pension. And there it will sit, probably supported by a freezing injunction if a judge will grant it going forward. But that is, if this order is put into full effect, then what will happen is Mr. White will have received his pension and he will be holding it pending further order of the court.
And another way of putting it also is, as you say, you might like to seek a freezing order almost immediately that the money's hit the ground, so to speak. That shows, you would say, that the distinction, I assume, that the distinction that was drawn by Mr. Pomfret between receiving beneficially and receiving administratively can't be right, because it is received beneficially, and that's why you would need the freezing order.
Yes.
And it would only be received administratively if, in fact, this was all part of a single process.
Well, my lady, I wouldn't dissent from that because I don't need to in order to succeed today. But I'm not sure that it would ever be ministerial receipt by Mr. White, because Mr. White is receiving the money.
Well, it would have been ministerial receipt if you've got the order in the form that you originally asked for it, because he would have received it subject to an equitable assignment. I mean, the order, in fact, I'm not even sure it actually isn't the case. The order actually made was for payment, actually, can we actually look at it? The order that's actually made was for payment into a designated bank account in Mr. White's name, isn't it?
Yes.
So
I think this is tab 9, page 96.
yeah. So the difference that's happened is that instead of quotes receipt into the account, I think, of the solicitor acting for your client, which would not have been received by him on any way, shape or form.
Yes, if a different...
You now have a receipt into a bank account in his name.
Yes.
But it's a designated bank account.
Well, it's a bank account nominated by him that belongs to him.
Yes.
And I accept, my lord, that if a different kind of order had been made, then I'd be having a different kind of argument.
Yeah, but what you're saying, I thought you said it could never have been a ministerial receipt. And
yes, on the order.
My point was the first order that was sought would have been well, in fact, he wouldn't have been received at all. But to the extent he could be said to have received it, it would have been only ministerial, because it would have been for the benefit of your clients.
Yes, I apologise for the confusion, my lord. My submissions were directed at the orders under appeal.
Yeah.
So on the orders under appeal, and indeed on my Lady Justice Asplin's example, where it comes to him before being paid out to my client. So all orders are made all in one go. On those hypotheses, it wouldn't have been a ministerial receipt, and the reason is that he receives the money, and then at the next stage of proceedings, he is being compelled to use his money to pay a debt that he owes to my client, and he will get a discharge of that debt in return for the money of his that he pays over to my client.
But I'm not sure I would agree with that. I mean, let's take my lady's example, but let's be a bit more detailed about it. If the money is paid as the order suggested, the order actually made suggests it has to be into an account in his own name, in his own bank account. And prior to receipt into his own bank account, because you've been given notice of it, you apply and obtain a freezing order. That's the likely scenario I think was discussed this morning, so that the freezing order takes effect in advance to prevent the sort of disposals that you said would be objectionable. The money will then sit in Mr. White's bank account, owned by him, but subject to just a standard form freezing order. You can't dispose of it so as to defeat the judgment. But if the name is set up, you'd say that doesn't infringe.
Yes. Well, I think you just say that doesn't infringe, even if the freezing order is made ahead of time. Yes.
But if the order was to require the monies to be immediately, upon receipt, paid in discharge of the judgment debt, then doesn't that give rise to, again, an equitable assignment or a trust, because it's not free receipt by the individual. I mean, if I say I'm going to pay you £10 because I owe you £10, but only when you say that's fine, I'll do it on condition that I'm going to use it to discharge the debt that I owe to my junior. When you receive it, it's already impressed with the obligation to pay to your junior, and therefore it's not received by you. So if the order was to pay in advance over to your clients, then it wouldn't be beneficial receipt. If the money is being applied subject to an injunction, then in my submission that doesn't convert it from his beneficial property into my client's beneficial property. The reason my client is interested in the money is precisely because it is Mr. White's beneficial property, so that he can use it to pay a debt that he owes to my client. So if it already belonged to my client, then that would cut out a crucial phase of proceedings. It has to be his money in order for it to be used by him to discharge the debt he owes us. So you're saying it wouldn't infringe Section 91(2) if the court made an order that upon receipt into the designated bank account, he must use the money to discharge the judgment debt?
I certainly submitted that below, and if I have to take a firm position on it today, I will need to go away and have another think about it. But I'm not sure I'm not sure that it really matters, my lord, for the purposes of today, because the orders were made with a view to addressing some of the difficulties that had been identified, and at the risk of sounding like a stuck record, the appeal today is from those particular orders and not from different orders that might have been made but were not.
The judge is very explicit about the object. I've just gone back to paragraph 74 of the judgment, which we were taken to. The order is motivated by the objective of enabling that pension pot to be applied in satisfaction of a pre-existing judgment debt. That's its overarching object. And of course, all he's doing is putting piece one of the jigsaw in place, recognising there could be one or two further pieces of the jigsaw to achieve the object of this order, which is only stage one. Now, you're right that technically, theoretically, he's not restrained from receiving the pension, but the object, the explicit object of the order is to do that.
My lord, respectfully, it's not. The whole point of the order is to compel him to receive the pension so that there is a fund to enforce against.
Yes.
It's not, well, it's precisely not to restrain him from receiving it, because if he were restrained from receiving it, then we wouldn't be able to get it. So the whole architecture of the order is to compel him to receive it, okay. And then other steps may or may not be taken later on.
You know, again, boiling it down, that is again coming down to almost the difference in words between the two parties. You say technically he has received it, yet the object of the order is to create a theoretical right of receipt, because it is then that the pension pot is applied in satisfaction of a pre-existing judgment debt. That's what the judge says in paragraph 74. So it's a very theoretical argument. I understand it, I see it. It's quite a theoretical argument which elevates very high level of abstract form over the real substance and pith and purpose of the order.
I would respectfully disagree with the suggestion that it's technical or theoretical. The receipt has to be actual in order for there to be a fund for us or another creditor to potentially make an application for attachment in the future, which hasn't been done yet.
I understand.
Is that a convenient moment?
My lady, yes, thank you.
May I just say, over the short adjournment, I'd be grateful if you would all turn your minds to Rule 6A and Rule 6C of the pension scheme rules in this case. All of this has been proceeding on the premise that the debtor is entitled to receive and can elect to receive the entirety of the drawn down pension fund. And it's not clear to me that he is. If you would look at that, and particularly if you would look at what's said about Schedule 28 of the Finance Act 2004, which is in 6C2, I'd be grateful.
Call reference,
To what?
if able.